Hi guys, and welcome back. So now we're talking about protection from harassment. Okay, so the Protection from Harassment Act covers people who are neighbors, colleagues, it's someone that you know, or even if it's someone that you don't know, but they keep on stalking you, harassing you, verbally, psychologically abusing you, all forms of abuse, then you can apply under the Protection from Harassment Act. And the same principle applies. So you will either consult with your attorney or go to the clerk of the court and actually state out the incidents of harassment that this person has been doing, and you will obviously be granted, there will be two things, okay? You will either be granted with an interim protection order or a notice for the other person to show cause why a protection order should not be issued, and then you will get a court date. So the same principles apply. You need to state out the dates. There must be a pattern of repetitiveness, meaning that this person must be conducting misconduct, actually, harassing you, following you, calling you, loitering outside your workplace or home, all those kind of things, insulting you verbally, psychologically, emotionally, calling you names, doing all those kinds of not good things, then you can apply for protection order under the Protection from Harassment Act. Then you will be given a return date to court, because this matter has to be adjudicated in court, and the court must be satisfied that this person has committed acts of harassment, basically. And it's the same principle applies. This person must be served with the interim protection order or the notice to show cause why a protection order should not be issued, and you must not take it and put it away in your briefcase or your purse. You must go to the police station or the sheriff of the court to serve this other person. And if this is very important for both acts, the domestic and the protection from harassment, if this person is served with the protection order and it is sufficient service, and the court is satisfied that he was served, all right, then the court, and that person doesn't come to court, all right, on the return date, then the court will hear the matter anyway. If that person is not there, then they will either issue a final protection order, or just by looking at the facts of the case, either just dismiss it, but a hearing will take place. You will still have the duty to convince the court why you believe that a protection order should be granted against this person in your favor. Other people say, oh no, I won't go to court. But if you don't go to court and you were served, okay, then the court will definitely hear the matter and you will be issued with a final protection order. If you want to have that final order or that protection order set aside, there is an application that you can make to have that protection order set aside. Maybe at the time when you were served with the protection order, maybe you were still under quarantine. You had to complete your 10 days, and obviously you can't leave your house now and go to court. You can wait for the 10 days, right? And then approach the court and ask for but you must do it on time. And then you can ask the court to have that protection set aside, and you need to give reasons to say, maybe I was in quarantine, I was in a car accident, I was somewhere, I had to go elsewhere, maybe attend a funeral, all those things, and maybe that was the reason why you could not appear in court on your return date. Now, if you go back to court and the other party was not served, what happens there? Your matter will not be dismissed, but it will not be heard. What is going to happen is the court is going to give you another date, okay? So with this date, you have to serve. They will give you the paper again with the return date to serve on this other person. Now, we have dates of service, right? You cannot have a protection order with you today and serve it on the other person tomorrow, and the court date is the following day. That other person must be given at least 15 days to decide on what to do. In those 15 days, that person can decide whether they want to have an attorney, maybe they have to make arrangements at work. Basically it's just to give that other person 15 days to sort their life out, then come to court. Because if they are served and they were given that 15 days and they don't come to court, then the protection order will be confirmed by the court. But it is short service. You cannot say, but I served this person 5 days ago with the protection order. Why is he not here? Why is the court not granting me the final protection order? That is short service. Short, even if you served both domestic and protection, if you served a person 5 days before the court date, it is not sufficient service, right? And that person doesn't come to court. It is not sufficient service. The court is going to give you a date again and say, immediately go to the police station or to the sheriff of the court and serve this person within 15 days of coming to court. So when you get your notice or your interim protection order, you need to serve it immediately. If not immediately, depending on the court date, you must at least try to serve within 3 days of you getting the notice or an interim protection order, because a lot of people actually don't understand why, because they served to this person yesterday and they're in court and that person is not in court. Anything could happen. That person didn't have time to either call their employer, sort out their life, if they have big upcoming events to attend to. Now you just decided to serve them yesterday. The court will not hear that matter, even if there is a sufficient return of service. It is short service. Don't be frustrated. That's why I'm saying give yourself 2 to 3 days to ensure that that person is served. Now, another thing that happens in court is that people say, I served this person. He was served by the police. I don't understand why he's not here. I served this person on time. Then the court is going to ask you about a return of service. Let's say it is not in the court file. And then maybe you were there with the police when they served this person with the protection order, but the court doesn't have the return of service. Then that becomes problematic because the court needs to be satisfied that this person was actually served. So if there is no return of service in the court file and you go to court on your return date and the respondent is not there, the matter will not be heard. And people get frustrated and they say, but the police were supposed to file it. You need to ensure that you follow up with the police station to ensure that they actually filed the return of service. And you need to go to court before your court date just to follow up if the police served the respondent with the protection order, or if the sheriff served. If you use the sheriff, then the sheriff is going to give you the return of service to file on your own. I know that some police stations, some police officials, they actually don't want to give the original return to complainants. They would rather go to the court to file it. But it is very important that you follow up to ensure that the original return of service is in the file. Now, what happens if you have a copy of the original, a copy of the return of service? Will it be sufficient? Let's say you lost the return, the original, and you have a copy, or you decided to make a copy or take a photo when the policeman completed the return of service, but now it is not in the court file. The court still will not accept a copy unless it's under extreme circumstances that they do, but they hardly don't if you have a copy of the return. They always want the original. Everything that goes in the court file must be original documentation. Yes, and I hope that you learned a lot, because people get frustrated by these processes. It's rules that must be followed, both under the Protection from Domestic Violence Act and the Protection from Harassment Act. I do apologize for the noise, but I hope that you guys learned something. It is very important that you learn something, okay, when it comes to protection orders. It's not a matter of just going to court and getting a protection order, because other people think that once they are given an interim, that's it. It's interim, meaning it must still be made final and it has to be adjudicated in court. Stay safe, guys, and yeah, be well. And I hope to see you on the next one. Cheers.